Hi friends, I am your friend Advocate Namish Nigotia and you are watching my YouTube channel Legal Advice for Everyone. Friends, in this video, we will discuss Section 19 of the Family Act 1984. If a divorce petition is filed before a family court, whether it's a divorce petition under Section 13 or petition under Section 10 for judicial separation or petition under Section 9 for restitution of conjugal right, and if the family court pass any order or final order or decree where the aggrieved person has to file appeal, we will discuss in this video. Before I proceed further with this video, I would like to request that if you have not yet subscribed my channel, please do subscribe my channel, and you like my videos, please share my videos. Friends, what is Section 19 and how to file the appeal, where to file the appeal? So Section 19 of the Family Court Act 1984 says that any aggrieved person against the order or a decree of the family court who wants to prefer an appeal, he has to prefer appeal before the Honorable High Court. So I would like to read Section 19. What is Section 19? Section 19 says, save as provided in subsection 2 and notwithstanding anything contained in the Code of Civil Procedure or in the Code of Criminal Procedure or in any other law, an appeal shall lie from every judgment or order not being an interlocutory order of a family court to the High Court both on facts on law. What does it mean? Subsection 1 of Section 19 says that notwithstanding anything contained in Code of Civil Procedure or Code of Criminal Procedure, if any person is aggrieved by any order or decree of a family court, then he has to prefer an appeal before the High Court. What subsection 2 of Section 19 says, I would like to read. No appeal shall lie from a decree or order passed by the family court with the consent of the parties. If the parties has given consent to any order or decree, no appeal shall lie before the High Court. What subsection 3 of Section 19 says, every appeal under this section shall be preferred within a period of 30 days from the date of judgment or order of a family court. This subsection is very important because there is inconsistency between the Family Court Act Section 19 subsection 3 and the Hindu Marriage Act 28 Section 28 subsection 4, which says that period of filing the appeal is 90 days. Kindly understand, if there is family court has been established, Section 19 of the Family Court Act will apply. Where the family court has not established and the power is still lying with the principal district judge or magistrate court under Section 125 CRPC, then Section 28 subsection 4 of the Hindu Marriage Act for preferring an appeal will apply. So you have to keep in mind what is the period of limitation. You understand it that if the family courts has been established, then Section 19 subsection 3 will be applicable, where the period of limitation has been prescribed as 30 days as against any appeal or order passed by the family court, where the family courts has not been established till the date and the suit or a petition under the divorce petition under Section 13 or petition for restitution of conjugal rights under Section 9 of the Hindu Marriage Act or petition for judicial separation under Section 10 of the Hindu Marriage Act tried by the family by the civil court or the district and session court, or where Section 125 CRPC is tried by the magistrate court, the appeal will lie according to the Hindu Marriage Act Section 28(4). In case of Section 125 CRPC, the revision will lie as mentioned under Section 397 of the Code of Criminal Procedure before the sessions judge. Now I would like to read subsection 4 of the Family Court Act 1984. The High Court may, of its own motion or otherwise, call for and examine the record of any proceeding in which the family court situate within its jurisdiction passed an order under Chapter 9 of the Code of Criminal Procedure for the purpose of satisfying itself as to the correctness, legality or priority of the order not being an interlocutory order and as to the regularity of such proceeding. What does it mean? It says that High Court of its own motion can call for any record for its examination where the family court is trying the matter under the code of the criminal procedure chapter 9. Now what subsection 5 of the Family Court Act says? Section 19 subsection 5, except as aforesaid, no appeal or revision shall lie to any court from any judgment, order or decree of a family court. I would like to read it again. Except as aforesaid, no appeal or revision shall lie to any court from any judgment, order or decree of a family court. What has been provided under section 19, the appeal is lies, except as otherwise provided, no appeal shall lie. What subsection 6 of section 19 of the Family Court Act 1984 says? I would like to read. An appeal preferred under subsection 1 shall be heard by a bench consisting of 2 or more judges. It can be heard and decided only by a bench consisting of 2 or more judges. Single bench cannot hear or decide the matter. Now the question is how to draft the appeal. So name of the High Court has to be mentioned, then title of the appellant versus the title of the respondent, then head note, details of the family court, case number, title and the date of the order and designation of the judge. Then you have to state the facts in brief. Whatever the facts, whether the facts was based on the petition has been filed on the basis of the adultery, cruelty, desertion on any other ground mentioned in section 13 of the Hindu Marriage Act. Then you have to mention the grounds of appeal. The general grounds of appeal that the learned trial court has not appreciated the material available on record, that learned trial court has not appreciated the settled legal position, the learned trial court has not correctly appreciated the oral and documentary evidence produced by the parties, the learned trial court has not appreciated the latest legal position of the subject matter. These are the general ground. And now the period of limitation and jurisdiction is very important ground. So as I said earlier that 30 days is the period of limitation. So you have to be very careful and you have to file an appeal within a period of 30 days. Then you have to mention the jurisdiction, that this Honorable High Court lies the jurisdiction, and you have to make a prayer. In prayer you have to state that the appeal may kindly be allowed and the relief in the divorce petition may kindly be granted. Now question arises, what documents you are required to file along with the appeal? So you have to file memo of appeal, stay application, wakalatnama of the counsel, certified copy of the judgment and degree, and certified copy of the entire record. It is very important. You have to file the complete paper book of the file of the learned trial court. Now with respect to the jurisdiction, I would like to discuss here a very important judgment of the Allahabad High Court decided on 5th of March 2009, and the title is Ashutosh Kumar versus Anjali Srivastav. What was the finding of this judgment is, I would like to read. Period of limitation for filing under section 19 of the Family Court Act is 30 days, but period of limitation under section 28(4) of the Hindu Marriage Act is 90 days. Where family court established and judgment and order passed by it, appeal against such judgment and order would be under section 19 of the Family Court. And provision of section 28 on appeal of Hindu Marriage Act fails into insignificance and suppressed by section 17 of the Family Court Act. Hence period of limitation for filing appeal as provided under section 19 of the Family Court Act to apply, which is 30 days. So in this video we have discussed that where a divorce petition is filed before the family judge, how to file an appeal, where to file an appeal, and what is the period of limitation. Thank you so much, friends.